Hello, 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 beautiful people. As always, welcome back. Trust. You finally figured out that, okay, maybe trust is the path to go. Good. Taking one extra step to where you intend. Good. There are two main scenarios that people deal with that causes them to run to and fro looking for a solution. In the process of that, they run across wolves and vampires who take advantage of them. You know, the good old quick talk, sharp talk, valiant talk, smart talk. In the process of them running to and fro, you run across people like that. Maybe they run across those who don't want to take advantage of them. It simply requires them to put value into what they want their solution to be. Because it is very true. Once you start giving people free stuff, they don't value it. They start to believe you owe them things. They believe you owe them energy, time, essence, and information. But in truth, those they're running away from, they don't have the balls to behave towards them that way. And when they do, they don't back it up with competence. A lot of issues. But nonetheless, in between all that, there are two main dimensions. The first dimension is stuff hits the fan and they try to find a solution. The second dimension is they anticipate stuff is about to hit the fan, so they quickly try to find solution. Let's speak about that first dimension. The first dimension is when stuff already hits the fan, now you're creating a trust. Here's another caveat. If someone is telling you to create a trust and they're not introducing the foundational principles of fraudulent conveyance into the total spectrum or your point of view as to why, when, and how you're creating that trust and how to use it. You're not just creating a trust. Remember, you're creating it to use it. You are going to put it to use. Creating a trust is synonymous with someone who's been walking on foot every day back and forth to everywhere. And finally, you got a vehicle. But once the winter comes, you got the vehicle, it's working. But you're still walking to and fro. Well, the trust in this scenario will be synonymous with the vehicle, because that's the medium that will take you where you want to go quicker and more efficiently, with less pain and more swiftly. But the problem is you don't even know how the mechanics of the vehicle works. Even worse, you got a stick shift. You got an idea of how the automatic works, but what you bought was a stick shift. And you're thinking, oh shoot, I can't just wing this and mimic what I've just saw other people do. Especially express trust is a stick shift. You can't just merely mimic what other people do. You need the intricacies of it. You need to learn how to use a stick shift. And one of those stick shifts is something called fraudulent conveyance. See, the reason why most people don't get the fact that there are intricacies to what they do and what they desire is because they lack certain skills. And this is being brought up not to make you feel bad. If you do, oh well, too bad. But more so, this is being brought up to highlight in your mind attention and a focal point of something that you might not have, but you need to make things work for you. And it is this. Half of what most people need as a skill set to make things work is an interpersonal skill. When it all comes down to it, you can learn all the intricacies like the one we're about to talk about in this video, all you want. But if you lack interpersonal skills, aka emotional intelligence, your ability to deal with your fellow humans and actually learn to articulate and speak with them without just waiting to lash out or waiting to prove that you know something or wanting to just get your piece out. When it comes to the world of trust, the world of equity, the world of true honor and dishonor principles beyond speculations of what people have been throwing around bantering, when it comes to that realm, if you don't have emotional intelligence of a certain level and interpersonal skills of how to deal with people, You will create trust all you want, and that trust will not work because the foundation of that trust is your interpersonal relationship, hence that word trust. You have to trust the people that are the members, trustees, trust protectors, beneficiaries, and authorized representative of that trust, for them to then interface by way of that trust with other trusts, which they are doing in a constructive manner, whereas you're expressing yours. If a trust is interfacing with another trust, a trust, yours being expressed, theirs being constructive. And in some cases, their trust is expressed also. If one trust and its members are interfacing with another trust and the other members, that's a trust relationship. In other words, there are certain etiquettes that you need. If you go around speaking with people by way of trust, like you got something stuck up your butt and you think somebody owes you something, they will slap you with something like this called fraudulent conveyance. So know about this beforehand so that you don't think you got everything figured out just because you're now caring about a trust or you're using a trust one way or the other based on your limited concept of what a trust is. See, guaranteed 90% of everything that you will hear about a trust on the internet in whatever social group, 90% of that accounts for less than 10% of what you need to get it done. I will say that once and I'll leave it there. Maybe the exceptions might be what you hear here on this page, here and there. But even then, if the exceptions were to be introduced, for instance, in this case, the fraudulent conveyance, and the exceptions being what we go over on the Patreon page regarding trust, that exception can only really bump you up to about maybe 50-60%. The other 40 or the other 50% that you will need will be your emotional intelligence and your interpersonal skills. Most people lack interpersonal skills and emotional intelligence. The value of your trust and the extent of the effectiveness of your trust is based on your capacity and your ability. You can name your trust whatever you want, you can structure it properly. If you are incompetent and uneducated, as I always say, education is the process. Liability compels performance. And where liability does not compel performance, value does. If you are not competent enough to hold people liable or present value on the table to compel performance by way of that trust that you're attempting to use, it will flip the table on you so quick, you will not even know what happened. And one of the ways they will flip the table on you is something called fraudulent conveyance. If you're in a dimension of whereby the stuff has already hit the fan and you're looking for a solution. If the stuff has hit the fan and you seek a solution, that's fine. The solution can still be used. But be aware of this so that you can read in between the line of the way they are interacting with you. What you are, in other words, if it's not clear at this point before we go into fraudulent conveyance, what you are is synonymous to gold. What they are is synonymous to any other currency used to purchase the gold or any precious metal. Whenever anyone purchases any precious metal, the value of that precious metal stays the way it is. The value of that precious metal does not change. It is fixed. What changes, though, is the value of the currency that you are using to purchase that precious metal. So two people can buy 1 ounce of gold, but it might cost them a different amount based on the currency that they're using to buy that 1 ounce of gold. The ounce of gold of weight is fixed, but the amounts and the value based on the currency that's used, maybe the dollar or the yuan, if you use a yuan to purchase gold compared to a dollar, it will be different amounts. You are that gold, and those guys on the other end are the currencies that interface with you. In other words, they are mutable to you. They are mutable to what you do, and you are the value to which their mutability have to work around in order to interface with you. You are the value that they have to bend and stretch over and backwards to reach. You are the gold. They are the fluctuating currencies. You will read Constitution's Res Judicata that says that the people are the ones who create the government, and the government is amenable to the people. People have inalienable rights, so and so. It's basically what it's saying. And that's basically what we're saying here. You and what you do is so valuable that nobody can shake you or move you. And what they do is very, 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 very feeble. It's not as strong as what you naturally are. But if you do not have emotional intelligence, and when you lack interpersonal skills, when it comes to the use of trust, the table will be flipped on you so quick that you and what you are doing will lose value. And they will play the role of God over you. They will play the role of sovereign over you, who holds the gold and the power. Competency is what you need, not the next buzzword, not the next hype train. And on the note of competency and how they will flip the table on you when the stuff has already hit the fan, it's called fraudulent conveyance. And this is a regular practice when it comes to trust affairs and contract law. So listen carefully. Fraudulent conveyance. A fraudulent conveyance is the transfer. Now, first of all, within the title tell fraudulent, on the Patreon page, we go in great details on fraud, different types of fraud, the elements of fraud, and the different examples of the different types of fraud. So one, if you don't know what fraud is, the different types of fraud, the standard to the different type of fraud, and the examples of functional aspect of the different type, you just be reading this term for fraudulent conveyance and you would think you know what's going on. Conveyance, when it comes to trust law, simply means the transference of something from one place to another, like trust decanter. A fraudulent conveyance is the transfer, aka conveyance, of title to real property for the express purpose of putting it beyond the reach of a known creditor. Real property, land, law. So you have mortgage, right? You're trying to use an express trust, right? The mortgage is active. They've initiated it in the stock market. They've done the CDOs and all that. Okay. So now you put in your express trust, right? All right. Well, they have something for you called fraudulent conveyance. Property signifies dominion or right of use, aka usufruct, that we've been going over, control, and disposition, to get rid of, which one may lawfully exercise over a thing, object, or land. In other words, property is not limited to land. And specific to this world, real relates to land. One of the basic dividing lines between property is that between real property and personal property. Generally, the term real property refers to land. Generally, the term real property refers to land. Land is in its general usage, includes not only the face of the earth, meaning the crust, the soil, the stuff that you step on, but everything of a permanent nature over or under it. Air rights, mineral rights, water rights, blah, blah, blah. This includes structures and minerals. In other words, real property deals with the land, the air, and the minerals. And on the note of people trying to put their house, land, whatever it is, remember, once more, that mortgage has nothing to do with the land. That land of yours is just being used as a collateral. The mortgage itself that's being foreclosed against is the contract. The contract that was signed was what's being foreclosed. The land is just a second-hand replacement for lack of performance and lack of honor. So you've entered into a contract where you use something as a collateral, right? And now you're trying to, retroactively put that property that's used as collateral into a trust. Well, the good part about equity, just so it wouldn't just be doom and gloom, but in order for someone to first give you the bright side with the rainbows, unicorn, and leprechaun that you can skip in the La La Land. First, I have to give you the doom and gloom so you become realistic. But the good part about equity is equity does that which ought to. So you can, in fact, retroactively do it under fixed conditions that we will not be talking about here on YouTube, but we'll be going over on Patreon as time goes on. But know this caveat first before you even want to entertain that, which is fraudulent conveyance. A fraudulent conveyance is the transfer of title to real property with express purpose of putting it beyond the reach of a known creditor. Well, this is what most people intend to do with mortgages and trusts, right? They already have the mortgage established. They're already fractionalizing into CDOs. They're already bundling it up with AAA, AA, triple B mortgages, and they're doing their thing on their back end to make money. And you're over here realizing, oh no, I made a wrong decision. Then you dispute what's going on. Okay, what's going on is that you need to first know what is going on so that you can take a step properly, that first step properly into fixing what's going on. If you do not know what is going on, you cannot fix what is going on. It's a very simple equation. And what is going on not only involves their end, but the totality of circumstance, which involves your end and what you are doing. And part of what is going on that most people do is called fraudulent conveyance, unless they know the exceptions according to equity. A fraudulent conveyance is a transfer of title to real property for the express purpose of putting it beyond the reach of known creditors. That's what people do. That's what people now intend to do. Now they figured that trust is the way to go after a mortgage has been signed. They're trying to take it out of the hands of the creditors who say, well, you use this as a collateral, so we're going to take it. But you didn't enter into that contract by way of the express trust, showing its face one way or the other. So now you're trying to, after the fact, you use that as a collateral, bring the express trust into the equation in order to hide that property. All right. In such case, the creditor may bring a lawsuit to void the transfer. In other words, they can annul that attempt that you just made in order to transfer that property into that express trust by suing you. And guess what? They can do something called an interpleader merged with that foreclosure process that's already going on without having to open a separate case. And if they really want to do you, quote, dirty, if they want to do you dirty, they will open a separate case based specifically of fraudulent conveyance, just like you can open a case based on quiet title. Well, they can do the same thing for fraudulent conveyance separately from that lispendence that's active, from that foreclosure of that contract that you signed that's active, and they won't let you know. If they're real kind about it, they'll just do a supplemental or amended pleading into the foreclosure, bringing forth this claim. This occurs when a debtor, presumably the quote homeowner, seeks to take advantage of their creditor, presumably quote the mortgager, the mortgage company, the one giving you the monies, to say, all right, giving you the pretense of transference of money, which, by the way, is part of the exceptions. But let me just briefly put it out there. The exceptions begins, it's 5 exceptions. 2 of them is the issue of title, which we go over on Patreon, and a preview of that is posted here. And the second is the issue of consideration. But the issue of title comes in first before consideration, because consideration is after there's a presumption that, okay, someone has a title to even enter into this contract, let alone before talking about whether consideration occurs or not. But those are 2 of the 5 exceptions. Nonetheless, fraudulent conveyance, if they were to bring it to you, occurs when a debtor seeks to take advantage of their creditor by structuring a transaction with the intent to hinder, delay, or defraud their creditor. See 11 U.S.C. 548 A1A. Do you know what Title 11 deals with? It deals with bankruptcy. Ask yourself, why are they referring to bankruptcy as it pertains to fraudulent conveyance? Let me give you this short answer. Because the presumption is based in subrogation, and that you are presumed to be the one that's bankrupt. Thus, these foundational rules apply to you because your status is presumed to be bankrupt, because the only one that they would allow to engage in that contract of mortgage is usually that is legis that you use, which is bankrupt, although they insure themselves against it so they can still keep cashing out by way of that Social Security insurance. But the question is, are you insured? But moving on, the owner of real or personal property does so by either seeking to place land or goods beyond their creditor's reach. This is what you're doing when you put it in express trust after a mortgage exists, without implementing some of the 5 qualities required. 2 of them has been mentioned. Operating to the prejudice their creditor's legal or equitable rights, meaning they're saying we have equitable interest in this also, or operating to prejudice the legal or equitable right of third parties. These third parties, I'm telling you, the CDOs, they call it collateralized debt obligation, which is the good old quantitative easing that we're going to go into the deep details and explanation and show it on Patreon. Constructive fraudulent conveyance is generally a transaction for less than reasonably equivalent value made when the debtor was insolvent or became insolvent. This word insolvent is just another fancy word for a bankrupt. Upon the transfer, the debtor must have intended or believed that they would incur debt that would be beyond their ability to pay as these debts matured, or made this transfer to or for the benefit of an insider under an employment contract outside of the debtor's ordinary course of business. To file an action for fraudulent conveyance, the transfer must have been made or incurred within 2 years before the date of the filing of the bankruptcy petition. We'll stop right there. What you ought to think about are those details. I'm quite certain you've heard of people entertain the concept of piercing a corporate veil, or piercing a trust. The trust is going to be pierced. That is just a blanket term that has intricacies involved, specific to the subject matter and the type of contract. The piercing of a veil of corporate entity or the piercing of a trust is specific to the subject matter. Sure, one of the ways your trust can be pierced is how you organize it, but what if you organize it correctly? Now the next step is, how are you using that trust? It can still be pierced that way. When it comes to the piercing of any trust or any entity, corporate or otherwise, fraud has to be involved one way or another. And if you're going into a playing field whereby you're putting your property into an express trust and you don't know one of those playing fields, you are stepping into an abyss of fire. We'll stop right there. Put those into consideration and think about it. But the good part of it all, to end with, is there is solution. But solution only exists as a twin companion to a problem, because no problem exists where solution doesn't. But if you don't know that a problem exists in the first instance, it will catch you by surprise, and in a battle which they will be fighting against you based on their commercial interests. The element of surprise is what screws most people over. Just as much as in any battle, the element of surprise is important to be a victor. Don't be caught off guard. Don't run with the hype train. Don't run with the trend. Be competent, because most of the people around you using certain words, entertaining certain subject matters, are really not as competent as they want to appear. Most of them don't know how to get down to it when it's really time. Most of them don't know the intricacies involved in the subject matter being thrown around. You be that exception. You evolve past the level of being mundane. Until next time, take care. Best of luck. Beautiful people, I'm inviting you to join my Patreon page. The things we speak of over there are basically synonymous with webinars, each videos, when it comes to the quality of information and the actual aspect of it compared to the one here on YouTube. We speak about residual income and how to sue people, make residual income if you're willing to do that. We speak about tort and garnishment, remove the speculations of maritime lien. We speak about banking, express trust, all the intricacies that are important. We speak about trust-related matters, different types of trust, how to actually function in commerce. We speak about the intricacies of how to actually do the W-8 ban and what makes it foreign, what tax treaties are, the stuff people won't tell you about. We speak about things of spiritual nature. We speak of child support, the intricacies of it, how it's all property right, and how cloud of legality is brought to life. Exactly how they do it and how you tackle that beyond speculation. We speak about how laws are made and how it's applicable or not, the intricacies according to the Constitution. We speak about the truth of what most people are fearful and speculative about. We go over the elements of the things that people need to know when they make claims to sue people to make money, either criminally or civil. When it comes to substantive right, we speak about the venue and the playing field that a lot of people don't know that they're stepping into. If you don't know the venue and the playing field you're stepping into, you're in for a world of hurt. We clarify misconceptions. We speak about the intricacies of things we speak here on YouTube, but more in details on Patreon. Basically, stuff that are on YouTube are synonymous with things that are for the birds. One on the Patreon are the premium quality things. In the past, we went over IRS manuals in different ways when it comes to the express trust 98 number. We went over the intricacies of mortgage, land, title. We went over issues with things like driver's license and the treaties that are the solutions for it based on examples of my own first-hand knowledge and experience. Speaking about trust-related matters, more on child-related issues. We discuss other aspects of things. We discuss how to really come in as a natural person and the fact that there are actually tools that pre-exist that are meant to be used. A lot of people say, well, don't use this, don't use that. Well, do you know that same thing you're running away from is actually the solution? And do you know that's one of the ways and your first step to actually garnish it? We speak about the intricate details of discharge. We speak about things of reality that goes over people's heads. More in discharge, we speak about the functionality of spirituality and cosmology and astrology and how you can actually put it to use. We speak of the what, why, and how, and the importance of a foreign trustee and the resident status. We speak about spiritual things when it comes to plant, the functional aspect of it. We speak of the language of the difference and the truth of legislative fact compared to adjudicative fact and what it really means when it comes to judicial notice. We speak about the lunar mansions, how to put them to use. We speak about tort, U.S. Marshal Service. We upload documents and treaties, original certified copies. Tax evasion, we show the IRS manual that shows the difference between tax evasion and tax avoidance. We go more in about how to actually make your own pocket bigger in commerce. We show the videos and experience that I have when it comes to discharge and the explanation of it. We show elements and details. We speak of the things relating to holding people liable. Speak about the different intricacies of how these entities are used against you and how you ought to use it and to know the playing field. A lot more that a lot of people are seeking but will not find. Again, each of these videos are synonymous to webinars of their own. We speak about how to get rid of statute of limitation. Most people's remedies, they say, are barred by statute of limitation, but there's a way out to that. We speak about how child supports are private and how and why they want to charge you thousands of dollars for some transcript, how to nip that in the butt, and a different aspect of it in great details and in great increments. Speak about the intricacies of fraud, how to prove it, the different types and the elements to it. Speak about tort. Speak about speak about trust. Speak about the subtleties of invoking equity and how to structure your document, and so on and so forth. Speak about private right, the incorporation doctrine, how people use UCC 1-103207-308, how that really doesn't actually preserve your right, contrary to the speculation that a lot of people throw around, and that your solution is actually in plain sight beyond the volatile and immutable UCC, which, by the way, the UCCs are also copyrighted. We speak about spiritual things in nature, how to use flame, and the functional aspect of beyond make-believe. I show my own first-hand experience in Chancery Court, and so on and so forth, and a lot more to come. Till next time, take care. Best of luck.